and welcome to In Depth. I'm Tina Jha. India's forests are home to lakhs of people, including the many scheduled tribes who live in or near forest areas of the country. In 2006, the Forest Rights Act was passed to give legal rights to these forest dwellers, their homes, lands, and livelihoods. The Act is crucial to the rights of millions of tribals and other forest dwellers spread across multiple states of our country, as it provides for the restitution of deprived forest rights. But several wildlife groups say the Act has encouraged further encroachment on the already battered forest lands. Challenging the constitutional validity of the Forest Rights Act, they filed several petitions in the apex court in 2008. In the long-drawn case, the Supreme Court on 13th February this year directed 21 states to evict illegal forest dwellers whose claims over the land have been rejected by the authorities. The eviction order could have affected 11.8 lakh forest dwellers residing in different parts of the country. However, following the centre's appeal, the apex court has put on hold the eviction order passed on the 13th of February. Today in Depth, we look at the eviction order of the Supreme Court in detail and what is the centre's contention on the issue. We also analyze the Forest Rights Act of 2006, its significance, and the challenges being faced by forest dwellers in the country. Dealing with a batch of petitions challenging the validity of the Forest Rights Act, the Supreme Court on 13th February directed 21 states to apprise it about the action taken by them over the eviction of tribals and forest dwellers whose claims have been rejected. The court said once the orders of eviction have been passed, the eviction ought to have taken place. The order was bound to affect nearly 12 lakh people residing in or near forest lands. But with the Ministry of Tribal Affairs seeking modification of the order, the apex court has agreed to put on hold its eviction order. What was the February 13 order of the Supreme Court and what did the centre say in its plea? Let's understand in our next report. In a major reprieve for 12 lakh forest dwellers and tribals, the Supreme Court on Thursday stayed its February 13th order that could have resulted in their forcible eviction from forest lands. A two-judge bench comprising Justices Arun Mishra and Naveen Sinha directed state governments to file an affidavit giving details about the process adopted in rejecting the claims of forest-dwelling scheduled tribes and other traditional forest dwellers.
Today, the Supreme Court has stayed its earlier order, which had in some way asked for states to update itself on the steps it has taken to evict those who are not eligible under the Forest Rights Act. Today, on an application that was moved by the central government, Ministry of Tribal Affairs, represented by the Solicitor General of India, the Supreme Court has stayed the execution of its earlier order and given 4 months' time, basically for the states to submit the progress with regard to the implementation of this act. And till that time, no evictions or any coercive steps should be taken by any of the state governments against any forest dwellers. Whether they are eligible or ineligible, that does not matter.
17 states, Andhra Pradesh, Assam, Bihar, Chhattisgarh, Jharkhand, Karnataka, Kerala, Madhya Pradesh, Maharashtra, Odisha, Rajasthan, Tamil Nadu, Telangana, Tripura, Uttarakhand, Uttar Pradesh and West Bengal submitted status reports on rejection of claims of forest-dwelling scheduled tribes and other traditional forest dwellers. Based on these reports, a 3-judge bench of the Supreme Court directed chief secretaries of these states on 13th February this year to ensure the eviction of these people from forest lands whose claims under the Forest Rights Act 2006 have been rejected on or before 24th of July. The eviction order of the Supreme Court drew flack from tribal rights groups and activists.
Background of this Forest Rights Act 2006. There is a principle in the international law that whoever occupies a land which is unclaimed would be owner of that land and he owns it. And this is one of the principles which was recognized when the Parliament took up this issue of, or the government took up this issue of bringing in a legislation to remove sense of alienation amongst the scheduled tribes of this country and other forest dwellers. The scheduled tribes have been the first occupants of that unclaimed forest, and they were depending on it for their livelihood as well as all medical purpose, food, etc.
On 27th February, the Ministry of Tribal Affairs moved the Supreme Court seeking an urgent hearing. In its plea, the ministry sought modification of the previous order. It urged the top court to direct state governments to file detailed affidavits regarding the procedure to examine all claims as well as the details of rejection. Till this was done, eviction of forest-dwelling scheduled tribes and other traditional forest dwellers was to be put on hold. The ministry also said that after examining the affidavits filed by the state governments, it could not be ascertained if the rejection orders were passed after following due process and whether appeal mechanisms had been exhausted. The centre further added that it has been periodically monitoring the implementation of the Forest Rights Act by state governments. The high rate of rejection of claims is mostly due to a wrong interpretation of the Act. The ministry also underlined a lack of awareness about filing claims among Gram Sabhas. In many cases, reason for rejections was not communicated to the claimants. The Ministry of Tribal Affairs contended that as forest dwellers are poor and illiterate, it was difficult to substantiate their claims before competent authorities. The Apex Court order on 13th February came in a case challenging the constitutional validity of the Forest Rights Act of 2006. A number of petitions were filed by an NGO, Wildlife First, and a few retired forest officials who argued that the Right to Forest Act has led to deforestation and encroachment of forest land. The petitioners sought recovery of forest land from the possession of forest dwellers. The case has been going on in the Supreme Court since March 2008. The next hearing will take place on 10th of July 2019. With inputs from Leena Sharma, Bureau Report, Rajya Sabha TV. The Forest Rights Act of 2006 was enacted to protect rights of forest-dwelling communities to land and other resources of the forest, which are essential for their livelihood. The Forest Rights Act also gives the forest dwellers rights to use minor forest produce along with community rights. The forest rights holders are also bound to protect and conserve biodiversity, wildlife, as well as forest resources of the area. The Scheduled Tribes and Other Traditional Forest Dwellers Recognition of Forest Rights Act 2006 was passed on 18 December 2006. Also known as the Forest Rights Act, it was enacted to recognize and vest forest rights and occupation of forest land for scheduled tribes and other traditional forest dwellers. These people have been residing in forests for generations, but whose rights have not been recorded. The Act provides the right to hold and live in forest land for habitation or for self-cultivation for livelihood by a member or members of a forest-dwelling scheduled tribe or other traditional forest dwellers. It gives the right of ownership, access to collect, use and dispose of minor forest produce which has been traditionally collected within or outside village boundaries. Community rights and rights of entitlement such as fish and other products of water bodies, etc. Habitat rights for primitive tribal groups and pre-agricultural communities. Right to protect, regenerate or conserve any community forest resource which they have been traditionally protecting and conserving for sustainable use. Right to in situ rehabilitation, including alternative land in cases where the scheduled tribes or other traditional forest dwellers have been illegally evicted or displaced from forest land. Rights of settlement and conversion of all forest, villages, old habitation, etc. into revenue villages. However, conversion of forest villages into revenue villages is to be adjudicated by the Gram Sabha sub-divisional level committee and the district level committee as per the procedure. The Act defines its beneficiaries as forest-dwelling scheduled tribes, which means the members of the scheduled tribes who primarily reside in forests and depend on them for livelihood needs. Other traditional forest dweller means any person who has for at least 3 generations prior to 13 December 2005 primarily resided in forests and who depend on them for livelihood.
Anyone who is dwelling on forest is not a traditional forest dweller. The person who is dwelling on the forest must be a traditional forest dweller and who has been residing this area for about 3 generations, in which one generation is 25 years. Even with regard to tribals, there is a requirement that you must prove, right, that you are dependent on the forest for your livelihood.
Along with the rights, the holders of forest rights also have certain duties to perform. They have to protect the wildlife, forest and biodiversity, ensure that habitat of forest-dwelling scheduled tribes and other traditional forest dwellers is preserved from any form of destructive practices affecting their cultural and natural heritage. Ensure that decisions taken in the Gram Sabha to regulate access to community forest resources and stop any activity which adversely affects wild animals, forests and the biodiversity are complied with.
There are a list of documents and the witnesses which needs to be proved. It's a fairly wide one, and every genuine person, the process which has been laid down, their claim gets recognized, and the ones who are making a false claim on the forest land for the use of rights, they gets identified. That's why that process of not only through the Gram Sabha, there is a difference in the sense that the Gram Sabha of a habitation, the rights first recognition has to take place, and then it moves to the subdivisional committee and the district level committee, and after that the vesting of rights happens.
The Act also provides for diversion of forest land for public utility facilities managed by the government, like schools, dispensaries, fair price shops, electricity and telecommunication lines, water tanks, etc., with the recommendation of Gram Sabhas. However, any of these facilities should not involve felling of more than 75 trees per hectare. With inputs from Leena Sharma, Bureau Report, Rajya Sabha TV. Time for a short break on the program. We'll be right back. Do stay with us.
Enter the majestic forecourt of Rashtrapati Bhavan and you'll come across the Jaipur College. A gift to the Viceroy from Savai Madho Singh, the Maharaja of Jaipur, to commemorate the creation of the new capital. The 145-meter high column is crowned with 6 pointed crystal stars on a bronze lotus, and inside the stone shaft runs a steel tube which weighs a little more than 5 tons. The base of the column has text conceived by Lord Irwin and Sir Edwin Lutyens inscribed on it.
Watch Security Scan with me, Vishal Dahiya, at 10 p.m. tonight, only on Rajya Sabha TV.
Art arisen from a multi-hued cultural canvas. Tradition and cultural fervour dating back centuries. And encircling them all, there's a magic that awes. Embrace your nation's brilliant human warmth. Watch Colours of India, Sundays at 9:30 p.m. on Rajya Sabha Television.
The Nehru Trophy boat race of Kerala, popularly called Vallam Kali in local parlance. This historic boat race dates back to 1952 when Pandit Nehru visited the state and a pageantry of boats accompanied him from Kottayam to Alappuzha. The race, conducted on the second Saturday of August every year, is a major tourist attraction. It's generally the snake boats which participate in the race, and hence the shape of the winner's trophy is also a replica of a snake boat.
The GST rates for the under construction projects which were slashed has come as one of the most decisive moves by the GST Council. What does it mean in terms of the impact on the economy?
Now the buyers will be more motivated to book the under construction home, and in the affordable category, the rate is now just 1%.
The GST rate on cement, that has not been reduced. Will it not be a challenging time for the developers?
Eventually, all the items in 28% will come down further. We have to also consider the revenue of the states and center.
How would you really counter this narrative that it's a buyer-centric move?
It is win-win for all. It is win for the consumer.
Watch to the point with the Union Revenue Secretary Ajay Bhushan Pandey only on Rajya Sabha television. Bhul Bhulaiya, a labyrinth of hundreds of narrow stairway passages, is a significant and historical component of what you popularly know as Bara Imam Bara. Some of these narrow stairways have dead ends, some end at precipitous drops, while others lead to entrance or exit points. Historically, Bhul Bhulaiya was constructed to confuse the enemy intruder, and the narrow lanes of the labyrinth can make anyone feel lost. The structure contains various strategically built hollows in the corridors.
Tales that inspire. Stories of social change. A salute to diversity. Promoting public discourse. Events that motivate. Inspiring the innovative spirit. Watch Rajya Sabha television documentaries.
Welcome back. You're watching In Depth. The tribal situation in India presents a varied picture. Some areas have high tribal concentration, while in other areas, the tribals form only a small portion of the total population. There are several challenges which the community has been facing, but the government has been giving greater emphasis to the development of tribal population and the area. Our next report details the challenges faced by tribals and forest dwellers and the steps being undertaken by the government.
The Supreme Court's stay on its earlier order has once again focused attention on the challenges faced by the tribals in India. Issues of tribal development, integration and autonomy have confronted Indian society right from the British rule. The complex nature of the tribal population has made their integration and autonomy even more difficult. Autonomy allows development policies to be shaped to help tribal culture and lifestyle. But at the same time, leaving the tribal in their own state only deepens the divide between the mainstream and the tribals. If tribals are integrated into the mainstream, their own needs and desires are neglected. Also, exploitation of forests accelerated as most of the mineral resources fall in forest and tribal areas. Tribal lands were rapidly acquired for new mining and infrastructure projects.
Along with the rights, as it has been always the case, the certain duties have been assigned in this one. so that it's a natural resource which, if it is not managed sustainably, that will be depleting, and the worst affected people will be these poor tribals. And it's not just the scheduled tribes and the other forest dwellers who will be affected, because it's the question of losing the biodiversity, it's the question of losing the watershed of the major rivers of the country, which will be gone if it is not sustainably managed. So, keeping these safeguards, a legislation was brought and introduced and implemented across the country.
The main problems the tribals face are small and uneconomical land holdings, because of which their crop yield is less and keep them chronically indebted. The tribes follow many simple occupations based on simple technology. Most of the occupation falls into the primary occupations like hunting, gathering and agriculture. The technology belongs to the most primitive kind. Only a small percentage of the population participates in occupational activities in the secondary and tertiary sectors. Besides this, literacy among tribals is very low. After independence, many steel plants, power projects and large dams came up in tribal inhabited areas. Mining activities were also accelerated in these areas. Acquisition of tribal land for these projects led to large-scale displacement of tribal population. Because of economic backwardness, tribals face health problems like malaria, cholera, tuberculosis, diarrhea and jaundice. Problems associated with malnutrition like iron deficiency and anemia, high infant mortality rates, low levels of life expectancy, among others. Degradation of the natural environment, particularly through destruction of forests and a rapidly shrinking resource base, has also harmed tribal women. Extinction of tribal dialects and languages is another cause of concern, as it indicates an erosion of tribal identity.
Developmental requirements, large chunks of forest were either diverted for agriculture, construction of dam, irrigation and mining for the requirements of the developmental requirements of the country. In the process, the scheduled tribes who used to live in these forests where the land was diverted, the sense of alienation grown in them, and to the extent that they were subjected to displacement, many of them, not just once, that many a times also this happened.
Some areas have high tribal concentration, while other areas, the tribals form only a small portion of total population. The Constitution provides special provisions relating to scheduled tribes. Article 342 lays down that President may specify the tribes or tribal communities or part of or groups within tribes or tribal communities or parts to be deemed scheduled tribes. Article 164 provides for a Ministry of Tribal Welfare in each of the state of Bihar, Madhya Pradesh and Orissa, which have large concentration of scheduled tribes population. Article 244 provides a fifth schedule in the Constitution for incorporating provisions for the administration of scheduled areas and tribes of the states which have sizable tribal population. The Constitution prescribes protection and safeguards for scheduled tribes to promote their educational and economic interests. Under Article 330 and 332 of the Indian Constitution, seats have been reserved for scheduled tribes in Lok Sabha and state Vidhan Sabhas. Government has also made provisions for their adequate representation in the services. Scheduled areas have been declared in the states of Andhra Pradesh, Bihar, Gujarat, Madhya Pradesh, Maharashtra, Orissa, Himachal Pradesh and Rajasthan. The scheme of administration of scheduled areas under the fifth schedule visualizes a division of responsibility between the state and union governments. The fifth schedule of the Constitution provides for the setting up of Tribes Advisory Council in each of the states having scheduled areas. Under Article 338 of the Indian Constitution, a commissioner has been appointed by the President of India to investigate all matters relating to the safeguards for scheduled castes and scheduled tribes under the Constitution and to report the President on working of these safeguards. Measures to provide educational facilities have been taken by the government. Emphasis is being laid on vocational and technical training. The central government awards scholarships to deserving students for higher studies in foreign countries. Tribal research institutes, which undertake intensive studies of tribal arts, culture and customs, have been set up in Bihar, Madhya Pradesh, Orissa, Rajasthan and West Bengal. With inputs from Leena Sharma, Bureau Report, Rajya Sabha TV.
So that's it from us in today's edition of In Depth. We'll be back same time tomorrow with a focus on some other subject. You can also watch our episodes online on YouTube and Twitter and get back to us with your feedback and suggestions. Thank you very much for your time.